The time between when the Articles of Confederation was ratified and the Constitutional Convention. And we talked about the Constitutional Convention and the fact that it was difficult to ratify. And in some cases, like the state of New York, it was one vote. And we know the guy, his name was Melancton Smith, who came to the Ratification Convention of New York, committed to voting against ratification. And once he discovered that the other big states like Virginia and Massachusetts and Pennsylvania had all been ratified and New York was going to be left in the dust, he changed his mind. That one single person that made it possible. Let me crank the volume up a little. Let me see if that's better. And so and the ratification, I guess, was a difficult process. One of the things that was done to help get it ratified in the state of New York, convincing Melancton Smith, were Alexander Hamilton, James Madison, and John Jay's Federalist Papers. And we may return later this fall with another 5-session overview of the 5 most important Federalist Papers. Federalist 10, 39, 52, 65, and 78. Those are the key Federalist Papers that you really should know something about. So we will give those a deep dive, perhaps later this year or maybe early next year when we get an opportunity to go over those. So here we are. And the Federalists, because of their superior arguments and in many cases superior advocates, carried the day, but just barely. And we don't want to forget about Virginia, because Virginia wasn't going to ratify either, except for the fact that the counties west of the Appalachian Mountains did not think the same way that the plantation elite did east of the Appalachian Mountains. So it was West Virginia that carried the day. Without West Virginia, it didn't get ratified in Virginia. So that already made those counties a little suspect on a different playing field. And in the Civil War in 1863, they seceded from secession. Figured that out. And became a state in June of 1863, probably illegally and unconstitutionally. I mean, technically, legally, technically, constitutionally, but that's if you believe that a restoration government in Alexandria that governed practically no one was the government of Virginia. Because the state government had to agree, and the real state government, of course, did not agree. So what was the compromise? What was the danger for the ratification? The danger was the Bill of Rights, or no Bill of Rights. And as one delegate to the Constitutional Convention said, who are we going to protect ourselves against? Ourselves? It makes no sense. We don't need a Bill of Rights. Well, a lot of people and influential people thought that we did. And so at the convention it was thought unnecessary, and James Madison in fact opposed it. Thomas Jefferson later changed Madison's mind. And so it's a bit of a quandary as to how Madison could go from being an ally of Alexander Hamilton to an enemy of Alexander Hamilton, and a bitter enemy of Alexander Hamilton. And Jefferson, in the case of Madison, changed Madison's mind. No Bill of Rights became the battle cry of the Anti-Federalists and an essential compromise in the fight for the ratification of the Constitution. So the Federalists promised that the first order of business, the very first order of business, would be a Bill of Rights. And then they went on and did a whole bunch of other things that had nothing to do with the Bill of Rights, such as the Congress being preoccupied with import duties, aka tariffs. And some would say, well, let's wait till the we didn't need to do anything until we figure out the specific problems that were identified. So, on May the 4th, 1789, the day before New York and Virginia were going to apply to Congress for a second constitutional convention, the day before that, Madison introduces the Bill of Rights to waylay this effort. He selected 17 from nearly 100 suggestions by the states. They were originally intended to be placed in the text of the Constitution at the appropriate point. But Roger Sherman of the Sherman/Connecticut Compromise changed their mind, said no, it has to be clearly identifiable, and let's put it at the end. So the House passed 17 proposed amendments on August the 24th, 1789. The Senate reduced the 17 to 12 by combining some and eliminating others, changing the language, and in many cases we have no idea why they did, because they did not keep a journal. Even though they were required to keep a journal, they did not keep a journal on this particular effort. So that will impact a number of the amendments, particularly what becomes the Second Amendment, and we will go do a fairly deep dive into the Second Amendment. So on September the 25th, Congress asked President Washington to send the proposed amendments to the state for ratification. Of the 12 that were proposed, the first 2 were not ratified. The second one in 1984, I'll have to go back and check that because I could, but the second one sits out there for over almost 200 years and becomes the subject of a college student's paper. And he gets a C on that paper, and then goes to war on behalf of his proposal that amendment was still live and could still be ratified, and writes hundreds of letters to state legislators and personally sees to it that ultimately it gets ratified. And the archivist said, looks live to me, it's the 27th Amendment. So what was originally to be the Second Amendment became the 27th Amendment. So Virginia's ratification on December 15, 1791 provided the necessary 11th state to ratify the Bill of Rights, and it became part of the law of the land. Massachusetts, Georgia, and Connecticut did not ratify the Bill of Rights until 1939, on the 150th anniversary of the ratification. And as noted, and this is a critical point, as noted in the decision Barron versus Baltimore of 1833, the Bill of Rights did not apply to the states originally. It only applied to what the national government could and could not do. And so as we go through here, we're going to see ideas from the Bill of Rights that are forced upon the states ultimately. We call that the process of incorporation. So whenever we're not talking a company here when I talk the Bill of Rights and we're talking incorporation. We're talking about your federal rights also becoming your state's rights. Okay, we already talked about the first 2 proposed amendments. Wait a minute, I just backed up, I think. Yes, no, I didn't have the right slide up. So there we go, just a little painting. The Bill of Rights ratified 1791, December the 15th. So the amendments are generally divided into 2 groups. First Amendment freedoms, those are big. We're having lots of discussions right now over First Amendment freedoms. Critical discussions. And protecting persons accused of crimes. So we're going to see, those are the 2 big groups. Not to say Second Amendment doesn't fall in there, Third Amendment doesn't fall in there, but the Fourth Amendment will. So the First Amendment is considered the most important. The rights specified are essential to a democratic government. Congress shall make no law. That's the critical, Congress shall make no law. And that principle is referred to as a state action requirement. It does not apply to private actions. First, freedom of religion has 2 parts. Congress shall make no law respecting an establishment of religion. This prevents and forbids the national government from creating or establishing an official church. Nor can it support one religion over another or religion over non-religion. So we got to keep that in mind, because we have, and I consider myself to be a Christian, but I'm one who has best of friends who are Jewish and Islam, and many students who were Islamic, and understands the need. The idea here was not that a Christian country was created by the Bill of Rights, but it was a country where many religions could thrive and be tolerated. That was the idea. Jefferson refers to this as a wall of separation between church and state. It did not originally apply to the states, so Massachusetts was congregational. Virginia, the Church of England, until, something called the American Revolution. So we couldn't have the King of England be the head of the church of the state of Virginia. So that's when Anglican became Episcopalian. From toleration to freedom, Maryland. So you have to understand that among the many prejudices that the colonists had was they were devoutly anti-Catholic. Put that together. But Maryland was the sole colony formed for Catholics. So the problem was more and more Protestants were coming into Maryland, and the legislature, I don't remember whether they called it the House of Burgesses or whatever, but whatever the legislature was in Maryland decided, we've got to protect ourselves. So they passed the Maryland Act of Toleration. It said, we good Catholics are going to tolerate Protestants. What it forced was that Protestants had to tolerate Catholics. So the language said one thing, exactly the reverse was true. And then George Washington's address. So we know where George Washington stood. And like I say, and I will say this over and over, without George Washington, you don't have a United States of America. Yeah. He truly was, as the author James Thomas Flexner said, an indispensable man. So George Washington visited the Hebrew congregation of Newport, Rhode Island. They wrote him a thank you for doing so. He responded to their thank you by saying, gentlemen, while I received with much satisfaction your address replete with expressions of esteem, I rejoice in the opportunity of assuring you that I shall always retain a grateful remembrance of the cordial welcome I experienced on my visit to Newport from all classes of citizens. The reflection on the days of difficulty and danger which are past is rendered the more sweet from a consciousness that they are succeeded by days of uncommon prosperity and security. If we have wisdom to make the best use of advantages with which we are now favored, we cannot fail, under the just administration of a good government, to become a great and a happy people. The citizens of the United States of America have a right to applaud themselves for having given to mankind examples of an enlarged and liberal policy, a policy worthy of imitation. All possess alike liberty of conscience and immunities of citizenship. It is now no more that toleration is spoken of as if it were the indulgence of one class of people that another enjoyed the exercise of their inherent natural rights. For happily, the government of the United States, which gives to bigotry no sanction, to persecution no assistance, requires only that they who live under its protection should demean themselves as good citizens in giving it on all occasions their effectual support. It would be inconsistent with the frankness of my character not to avow that I am pleased with your favorable opinion of my administration and fervent wishes for my felicity. May the children of the stock of Abraham who dwell in this land continue to merit and enjoy the goodwill of the other inhabitants, while everyone shall sit in safety under his own vine and fig tree, and there shall be none to make him afraid. May the Father of all mercies scatter light and not darkness upon our paths, and make us all in our several vocations useful here, in his own due time and way everlastingly happy. George Washington. So you see those powerful words. And Washington put those words into practice. When he would be with the commander of the troops, he didn't just he never hardly went to an Anglican or Episcopal church, in fact. But he made it a point of visiting all those churches that maybe somebody frowned upon. So he visited Catholic churches regularly as the commander, trying to set an example of religious toleration that I believe is so important. So, how high a wall if there's a wall of separation? Religion in schools. Release time for religious purposes? Bringing in teachers? Nope. Allowing students to go elsewhere? Yes. Parochiaid. Public support for parochial busing? Yes. Public support for parochial materials? No. School prayer. Non-denominational prayer? Nope. Bible readings in the Lord's Prayer? Nope. Moment of silence? Nope. Teaching of creation silence? Nope. Teaching of recapsulated under a new name. Teaching of intelligent design? Nope. And if you want to know the story behind that, I can't think of the author's name. She was a journalist in Pennsylvania, Lancaster, Pennsylvania. But I remember the name of the book, The Devil in Dover. If you want to understand the battle that tried to rip a community apart and rip the United States apart, read The Devil in Dover. And her father, the journalist's father, was an evangelical minister who thought she was going to hell. She thought she was going to hell, but she stood up and told the whole story honestly, frankly, and it's not a pretty story, and it's not a pretty story about the people who were behind intelligent design, knowing they were lying to the public, and got caught at it. So, equal access. Bible club or church in a school? Yes. Religion in the public square, holiday displays, if not solely religious, yes. Prayer in legislatures, you might have noticed. Whoops, did I? Yeah. Okay, sorry. That's the whole thing I get involved here. Now we're in the right place. Okay. Let's go one more, I think. Okay, no, I guess we are okay. All right. Yes. You might have noticed that Congress has a chaplain. Wait a minute, what about the division, the wall of separation? Well, here's the deal. The reasoning is, these are smart people in Congress, and it's not going to be easy to indoctrinate them. Therefore, we have a chaplain in Congress and in state legislatures. Or prohibiting the free exercise thereof, which challenges government policies that burden religion. Belief, absolutely protected, versus action, which can be regulated. So polygamy, illegal. Flag saluting cannot be forced. Compulsory education, only to the 8th grade. That was a case called Yoder versus Wisconsin, with the Amish protesting the fact that they were being forced to go to public high schools, and the Supreme Court sided with them. Now, what the Amish did was they created their own high schools, so their children wouldn't be indoctrinated in these public high schools, but compulsory education up to the 8th grade. And that matters a lot more than you might think. The National Social Studies model that was put in place in 1916 taught United States history in 3 grades. So not only did you get U.S. history in the 5th grade, you got it again in the 8th grade, and then you got it again in the 11th grade. And you might have wondered, well, why was that the case? Because each one of those was an exit point for a large group of students in a generally agricultural United States. 5th grade was the exit for farmers. 8th grade was another exit point. And in fact, those who had an 8th grade education in the 1920s and 1930s is easily equal to a high school diploma now, easily equal to it. And those that went through high school had an education the level of which easily matches a bachelor's degree today. So what they were trying to make sure at some point you didn't escape getting American history. Now the problem with that was you would hope that you got a little farther and a more comprehensive. No, I ended up at the 5th grade, we never made it to World War II. Now this is my generation. 8th grade, never made it to World War II. High school, I thought, finally, we're going to get to World. No, we never got to World War II. And that's where my dad fought in the Navy in World War II, so I ended up learning it on my own. Freedom of speech, or abridging the freedom of speech. Now I will get this. But what is speech? So pure speech involves only spoken words. Speech is debates. It has the greatest protection. Speech plus an action. The demonstrating and picketing. Speech in that is generally protected, but the action may be regulated. You don't have the freedom to protest in any which way you desire. Symbolic speech, sometimes known as expressive conduct. Burning a draft card, not protected. I didn't burn my draft card, by the way. But I was happy when I didn't need it any longer either. So, burning the flag, and this rubs people on the right very badly, the wrong way. It's protected, and it's protected in a Supreme Court decision called Texas versus Johnson, and I think written by Antonin Scalia, if I'm not mistaken, who hated it. Yes, Gary.
There was recently a presidential executive order.
It's unconstitutional.
No, but there is one that just happened. That
yeah, Texas versus John. Right. If they pay any respect for precedents, it's already been decided, and it's legal. I don't like it, but on the other hand, you know, what if I burn an Iranian flag? Those that love Iran might feel quite differently. So the right not to speak. You cannot be forced to recite the Pledge of Allegiance. And in many cases, my wife being one of them, when you get to the words that were added in 1954 during the Cold War of under God, people stop and are quiet during that point because that's not what the Pledge of Allegiance was about.
Tom?
Yes?
Where would freedom of the press come under that?
Oh, we'll get there.
Oh, okay.
So, and campaign financing. Money is speech. And that is a huge and horrible mistake to allow companies to be treated as individuals, and that money that they give cannot be regulated. And that has created, since that's Citizens United. It was that decision, and that was a very flawed and mistaken decision. Limits on free speech. Obscenity, not protected. Defamation, not protected. Fighting words that cause riots, not protected. Commercial speech. So I used to talk to my students about, let's talk about commercial speech. I'm going to talk about the Whopper. And everybody, okay. I said, yeah, the Whopper. I said, did you see how big that Whopper was in the commercial? And I said, have any of you ever had a Whopper the size of the one, as tall as the ones that are in the commercial? And they go, why no? I said, it's a lie, right? It's misleading. It's deliberately misleading. And I said, the consequence of that is we learn to accept things that we know aren't quite true and not question them, and that makes us more accepting of things we shouldn't accept. But that's commercial speech. Speech in special places. So neo-Nazis have no place in a Holocaust museum. That can be regulated. But neo-Nazis were able to walk on the streets of Skokie, Illinois, and but it worked out that almost no one showed up to walk, so it became a moot point. Speech and unlawful action, that is under no circumstances protected. So that's why when we peacefully protest in Port Angeles and Sequim, we have to be very, very careful not to create a situation where you are inviting somebody to send National Guard troops, because he's looking for any excuse, unfortunately. Freedom of the press. Now we will get to, I think, your question here. They cannot, or the press. So prior restraint, the government may not censure a work before it is published. Now, there are some exceptions to that. Well, they're trying. They're getting very good at it right now. And several incidents have pushed the limits on that, the Pentagon Papers being one of them, thanks to Daniel Ellsberg. But the Nixon administration did illegal break-ins into Daniel Ellsberg's office, trying to find dirt on him that would smear him so he looked unreliable, so that the Pentagon Papers wouldn't be believed, and we would not understand that the United States government had no idea what it was doing in Vietnam. And you have to get it into a big, broad history of Vietnam to understand why I say that. But the United States government was clueless on who Ho Chi Minh was. Yes, he was a communist. What did Ho Chi Minh want? He wanted to be Vietnam, what became North and South, to be free from colonialism, free from French colonialism, and free from what became American colonialism. And he went to the Treaty of Versailles Conference in 1914, or 1919, because he believed in Woodrow Wilson's 14 points. He was a Democrat, Ho Chi Minh was. But essentially, Woodrow Wilson, who was a racist, a flaming racist, brushed him off, "You little yellow man, this isn't meant for you." And so then what does Ho Chi Minh? He wants an independent Vietnam. So he tries to find any way, and it turned out that communism for him was the route that would make Vietnam independent. So that's why understanding Vietnam is I honor the people that fought there, but I don't honor the decisions the government made that put those good people in harm's way. So Shepard versus Maxwell. That's also known as the Sam Shepard case. You got to be from Ohio to know the Sam Shepard case. But he was a doctor in Cleveland who was accused of murdering his wife. He was set up. There's all sorts of evidence that he couldn't possibly have done it. But that evidence was suppressed, and the jury wasn't sequestered. The press had a field day in declaring him guilty while the trial was ongoing. And surprise, surprise, the jury found him guilty. It took several years before the Supreme Court reversed that and said trials must be fair, and they can't be fair if it's a circus-like attitude that's going on. And then you got the CIA. Some things have to be kept secret, and it's probably best that we don't know them. Just as the information that the New York Times just put out, speaking of issues that are relevant and timely, that there was a failed SEAL Team 6 effort to place a listening device in North Korea so we could track what Kim Jong-un was communicating. Unfortunately, for a bunch of reasons, it failed. And we just found, that was in 2019 in the first Trump administration. And he can't remember it now. So libel. Harder to prove when public officials are involved, because you've got three levels that have to be met. One is you have to prove that damage occurred. You have to prove that the perpetrator was untruthful. You have to prove that actual malice was intended, a very high bar. So, yes. Oh. Thank you. So, that is a very high bar that has to be met. I must note that Smartmatic met that bar in their suit against Fox News. They proved that they were untruthful. They proved that they intended to cause damage, and they knew what the right thing was and didn't do it, and had to pay almost $800 million as a result. And we're supposed to trust Fox News. Confidentiality. The court has ruled that no special privileges exist in criminal cases. Now, freedom of assembly and petition. Or Congress shall make no law or of the people to peacefully to assemble and to petition the government for a redress of grievances. That doesn't mean the right to riot, block public streets, etc. It can't be restricted because of content. It can be reasonably regulated, time and place. You may have to get a permit. You have no right to assemble on private property. And the Supreme Court has ruled that this implies a freedom of association. That just because you were in a crowd protesting doesn't mean you necessarily are responsible for what that particular crowd believed and what that particular crowd was advocating. Second Amendment, this is the tough one. The right to bear arms. Now let me get this out here. Because the author of the decision, Columbia versus Heller, a scumbag by the name of Antonin Scalia, deliberately misrepresents and misreads this amendment. So here it is. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In Columbia v. Heller, 2008, he said, well, it says, the right of the people to keep and bear arms shall not be infringed. Therefore, the District of Columbia cannot ban handguns. That's the logic. But he leaves off the first clause. And then he, who was the consummate textualist, saying, well, it means what they said it meant at the time. Well, we know exactly what it meant at the time because James Madison's original, would have been the Fourth Amendment, original Second Amendment was exactly the words that George Mason used in the Virginia Declaration of Rights, which reads as follows, that a well-regulated militia composed of the body of people trained to arms is the proper, natural, and safe defense of a free state. That standing armies in time of peace should be avoided as dangerous to liberty, and that in all cases the military should be under strict subordination to and governed by the civil power. So what was it all about? It was about state militias. Why did you need state militias? So you didn't have a permanent standing army. Why did you need state militias? To serve as your first line of defense and in case of invasion or revolution. So the whole idea of the Second Amendment is that the weapon, that yes, Americans have access to weapons. By that we mean a long rifle or a smoothbore rifle, not pistols, not machine. You don't have access to machine guns. Effectively you do with some of them, but technically you don't. So that was the idea, so that we wouldn't have a permanent standing army. So to divorce the concepts and say, well, the Second Amendment, as written, was poorly written, and we don't know why they changed the language, but they did. So we have to live with the lousy language we have, but it is clearly tied to having a well-trained militia, not for personal protection. Okay, so we skip here. So the idea to keep and bear arms, it's individual rights versus collective rights. And the Supreme Court weighs in gingerly. It's only got two decisions, basically. The first one was in the 1930s when you had all those revenuers trying to collect taxes from moonshiners, and the moonshiners had machine guns. The Supreme Court did ban machine guns, give the FBI a fighting chance to catch those moonshiners. And then Columbia v. Heller. The Third Amendment, no quartering. And for us, this, it's not a big issue. We don't have to worry about, soldiers living in our home. Well, we hope we don't have to worry about soldiers living in our homes. But 3 parts. The government is prohibited from forcing citizens to give room and board to soldiers in peacetime without permission. And the historical background is the Quartering Act by Great Britain to the United States, which forced the citizens of Boston to house and feed British soldiers, and they hated that. So that had a lot of traction, even in 1790. If a government does need to do during wartime, it must do so according to legal procedures, and this has been used to support the right to privacy, a right not specifically mentioned in the Constitution, but extant nonetheless, which Justice William O. Douglas referred to as penumbras. So you will see penumbra used later, and that's a right that isn't specifically spelled out, but it is implied that it's there. And we generally, as a society, agree that it's there. William O. Douglas was one of my heroes. Fourth Amendment. Now we get to the protecting citizens accused of crimes. The Fourth Amendment, search and seizure. 5 key parts. You have a reasonable expectation of privacy, the penumbra we just talked about. First, it was limited to home, office, and person. Later interpreted as people, not places. In Katz versus the United States, or I don't know if it's Katz or Cates. I didn't bother to look up the pronunciation of that. And let me see if I wrote down what that was. I did not. Oh, yes. The Fourth Amendment protects people, not places. Oh, I remember what it was. There was a guy who was running numbers, and he was calling from a phone booth. So the FBI bugged the phone booth, tape recorded it, had him dead to rights, and the Supreme Court says, wait a minute, he had a reasonable this is a public phone booth. We don't see much of those anymore, but a public phone booth, therefore he had a reasonable expectation of privacy. You did not get a search warrant to bug that private phone booth, therefore they overturned it. Unreasonable searches and seizures prohibited. Warrantless searches without probable cause. What this was used was to establish the stop and frisk theory that police departments use. This is Terry versus Ohio enabled that. And so if a police officer has a reasonable expectation that something isn't quite right, that they may stop you and frisk you, but then there's a lot of gray areas there. And it was clearly used by the New York police force to harass their black citizens. And they were taken to task for that. Reasonable searches and seizures. Consent searches, that you agree to it, but you can always say no. Sobriety checks, we see those. You got to be an idiot if you see a sign that says there's a sobriety test, checkpoint, and you've been drinking to go at it anyway. Airport searches, especially after 9/11. Drug testing. Student searches, probable cause not required. Why? Because the school is your ex loco parentis, your parent in the absence of your parent. The warrant, the warrant clause. You have to have probable cause. What are some major exceptions to probable cause? Incident to lawful arrest. You're shooting in a store and you run out and they see you, well, guess what? Okay. Plain view, you've left, they go up to your window and you've left the curtains open and there's all sorts of illegal drug paraphernalia out where it can see it. Guess what? You're in trouble. Hot pursuit. That's automobiles because of their mobility. Exigent conditions, fire, screaming, etc. All are major exceptions to having a warrant. Now we get to something called the exclusionary rule, which is a critical rule in criminal theory. And the idea of the exclusionary rule is that which is gathered illegally is inadmissible in a court of law. So the principle is established in Weeks versus the United States, 1914. It is incorporated, the Wolf versus Colorado incorporated the Fourth Amendment, 1949, and Wolf versus Colorado was that it protects you from unreasonable searches and seizures, but Wolf versus Colorado did not incorporate the exclusionary rule, didn't force the states to have to abide by it. Now, Mapp versus Ohio, you see a lot of versus Ohio here. There's a reason for that. So Dolla Ray Mapp was, the police thought she was a drug trafficker. So they got a warrant for that. Went in the house, didn't find anything, but they did find Playboy magazines that she was selling. So they confiscated those and arrested and convicted her, but they didn't have a legitimate search warrant. So this is what established that they had gathered the evidence illegally. It was nowhere in their warrant. Therefore, she was ultimately, the conviction was overturned. So, preventing government tyranny and protecting citizen security is the heart of the Fourth Amendment. The Fifth Amendment, we know that a lot because of a lot of people around Donald Trump saying, I plead the Fifth, and Donald Trump pleading the Fifth, I forget how many hundreds of times, but it's a lot. It's the longest and most diverse amendment, 5 key parts. What's a grand jury? Large, 23 people. It determines whether the accused should be prosecuted. Double jeopardy does not prevent a person from being tried for the same crime in federal and state courts. You cannot be tried for double jeopardy in a state court. You can't be tried for double jeopardy in a federal court, but you can lose it in the federal level and win it at the state, or lose it at the state and win it on the federal level, and that's not considered double jeopardy. Self-incrimination, taking the Fifth. Confessions, Miranda versus Arizona. And this is what leads to the famous Miranda warning. You have the right to remain silent, blah, 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 blah. One of our mock trial teams lost a trial because the person who was the police officer did not know what the actual text of the warning of the Miranda. Now, and he couldn't come up with a good reason, which I would have said, sir, I have it in my wallet. Let me get the card out and I will read it to you if you want to know, which is what I always do but we lost because it totally undercut the credibility of the police officer that he didn't know the Miranda warning. So, and the irony in the Miranda case was Miranda was later murdered, and the person that murdered him was read his Miranda rights. Due process, but only applies to the federal government. Procedural due process. So there are 2 parts of due process. Procedural is the government has to follow the rules and regulations and carry out the law. Substantive due process means that the laws themselves must be fair. So you can fairly follow crappy procedures, which happened a lot in the South against African Americans. But when you add substantive due process, that changes the whole ball game. Just compensation. Fair market value must be paid, and that restricts eminent domain. Taking the Fifth, as you can see, means much more than not testifying against yourself. And of course, it has different consequences in a civil trial than it does in a criminal trial. In a civil trial, in a criminal trial, it makes you look bad. But in a civil trial, taking the Fifth can be decisive evidence that you are lying. So, Sixth Amendment, fair trials. Well, what constitutes a fair trial in a fair society? Speedy and public. Why? Because one is presumed innocent until proven guilty, unless you're in Louisiana. Don't forget that Louisiana exception there, which is Code Napoleon, because it was originally French. Or Spanish, either one, Code Napoleon applied. So be careful in Louisiana. Justice delayed is justice denied, and trial cannot be too public. That refers us back to the Sam Shepard case again. An impartial and local jury, a petit jury, the small jury. For the federal, the required number of jury members is 12, but it can be a number of different numbers depending upon which state.
Good evening. The library will close in 15 minutes. Computers will shut off at 6 minutes before close. Please let staff know if you need assistance.
Okay, so defendants have appropriate tools. They can confront their accusers. This is a very, very slippery slope because Antonin Scalia was a hardliner on that. They physically have to confront. Well, what about a child who has been molested? And how terrifying that would be to have to physically confront their accuser. Scalia said it doesn't make any difference. There's no exception to that. He fortunately lost every time he made that argument, but that was still the argument that he made. You can compel witnesses, which happened in the case of United States versus Nixon, which was the Watergate tapes issue that went to the Supreme Court, of course. Nixon lost 8-0. One justice abstained. His name was William Rehnquist, and the reason he abstained, unlike justices on the Supreme Court now, was because Nixon had appointed him. And he would have voted, he probably would have voted against that, but it was 8-0 on the Watergate tapes. So the right to counsel. This is critical, because think of how many people really can afford an attorney if you need one. And so up until the case of Powell versus Alabama, which is better known as the Scottsboro Boys case, the Scottsboro Boys were railroaded in a trial on which they were clearly innocent and could not have committed all the rapes that they were supposed to have committed. They were sentenced to death. It was overturned because of the short time period that they were given to confess and the torture that was involved. And at this point, in the 1930s, let's see, Powell versus Alabama, 1932, the defendants in capital cases were given the right to have attorneys. Then they weakened it a little bit in 1942 in the case Betts versus Brady. Well, what happens if a person is of limited mental ability? Wouldn't they can't defend themselves. So the Supreme Court weakened it a little bit more and said, no, in the case that has special circumstances, without exactly describing what the special circumstances were, which left the states in limbo, until a guy by the name of Clarence Earl Gideon, who was a poor guy in Florida, in the Panhandle, and had to defend himself. He says, no, Your Honor, I'm entitled to a lawyer. And the judge said, well, not by Florida law, you aren't. And so he had to defend himself, and he did a super lousy job of it. But he wrote a personal appeal to the Supreme Court, applied for a writ of certiorari on 5 or 6 legal pages, handwritten, and the Chief Justice, Earl Warren, looked at that and said, this is the case we've been waiting for, to overturn the special circumstances and make sure that everybody gets a fair trial. Clarence Earl Gideon got his lawyer, got a new trial, and his lawyer destroyed the prosecution. So it ended up well. The Sixth Amendment gives the defendant a fair chance. Seventh Amendment, trial by jury in civil cases. Trial by jury is not just in criminal cases. The jury has the final word, not the judge. Bushell's case, which was the William Penn trial in 1670, the right is not an empty promise. A judge can only overrule a jury if, as a matter of law, the verdict was based upon insufficient evidence. Point counterpoint, is a trial more efficient if you choose to have a judge and not a jury? I think it depends upon the nature. If it's complex, do you want a knowledgeable, deeply learned judge, or a bunch of yahoos sitting over there that are your neighbors? Well, your neighbors might be sympathetic to you, but they aren't going to understand the complexity of the law. That's a case where you might want to have a trial conducted by a judge. Jury duty, burden or blessing. I have not been called to the jury. I'm a registered voter with a high level of education, and I've never been called. Georgia, who has almost an equally high level of education, also a registered voter, has been called 3 or 4 times, and called here. 5 times in Ohio. How many times here?
No, it was 3 times in Ohio and twice.
2 and twice here. And I'm a registered voter. I vote regularly. Come on, is anybody listening? Okay. I'm willing and able. 8th Amendment, rights after conviction. 3 critical rights. No excessive bail. It does not guarantee bail, and bail may be denied in capital cases. This has not been incorporated to the states. No excessive fines, not incorporated to the states. No cruel and unusual punishment. So capital punishment was considered inhumane treatment by some of the justices on the Supreme Court. They prevailed in Furman versus Georgia, which proved that the death penalty was being inappropriately applied much more to African Americans than white people convicted of the same crimes. So it was overturned in 1972, and in 1976, I think it is. Yes, reversed Furman, but it put a whole new set of rules to make the death penalty as a constitutional punishment for murder. So there is that limitation. The Ninth Amendment. So just because we didn't say it in the other amendments doesn't mean you don't have it. Okay, that's essentially what the Ninth Amendment means. So it's written to blunt the argument that the Bill of Rights would be incomplete, and some constitutional scholars, strict constructionists, argue that it gives judges too much power. Rights which we have but are not specifically listed include the following the Supreme Court has recognized. Right to privacy. Griswold versus Connecticut. Connecticut attempted to ban birth control, and that violated the right to privacy. The right to interstate and international travel. The right to vote. The freedom of association. Such rights are often hinted at or implied in the other amendments. 10th Amendment, federalism. This focuses on limiting the general powers of the national government, the only amendment proposed by all the states. It's an attempt to balance power. The states were worried about the federal government taking power away from them. It was. That was the design of it. And in the case of national supremacy, the McCulloch versus Maryland, this was a brilliant argument by John Marshall, where Maryland was attempting to tax the Bank of the United States, to tax it out of existence. And John Marshall ruled, no, the power to tax is the power to destroy. You cannot destroy the federal government. Then you have our famous Roger B. Taney, that wonderful legal scholar and the author of the Dred Scott decision, one of the worst decisions, and it was a lie. That's the even worse part of it. His whole history of the United States and black people in the United States was totally made up. He said, no African Americans fought in the American Revolution. Hundreds did. And hundreds, and in several states, 4 or 5 states, free blacks could vote. States initially pulled that back in some cases. But Roger B. Taney said, the federal government and state governments have their own individual spheres, and they're completely separate from each other. So, and that, of course, would be used as a justification for secession. And then you got nullification, John C. Calhoun, 1836, I believe, and said that South Carolina, a place that was too small to be, too big to be an insane asylum, and too small to be something else. I forget what the exact words are, but it was not spoken kindly of him. John C. Calhoun wanted to nullify, I think it was tariffs. And he said, South Carolina ain't going to abide by any of those federal tariff rules because we just ain't going to pay it. And Andrew Jackson, who, even though Trump uses as a model, was a much better president, not a great president, with a lot of baggage that he had, like the Trail of Tears, a lot of baggage. But Jackson said, that's fine, Mr. Calhoun. I will personally lead the Army of the United States down to South Carolina, and we will see who wins this argument. And the South Carolinian, it delayed the Civil War by 20 years, over 20 years. But Jackson meant it. He would have headed the Army, and he would have taken care of business. So states' rights versus civil rights. So we get to the Plessy decision of 1896, which established that separate but equal facilities for African Americans and whites was constitutional, even though everybody knew that the African American facilities in no way, shape, or form were the same as the facilities in schools for white people. That was overturned by the grandson of the justice that wrote the dissent. There was only one justice that dissented, John Marshall Harlan, in 1896. In 1954, his grandson, John Marshall Harlan II, wrote the majority opinion. That was fitting as far as I was concerned. And then we get down to the 14th Amendment, which has 5 sections. It's, as you know, the 14th Amendment has been in the news on and off because who's a citizen? Is anyone born in the United States an American citizen? The 14th Amendment says yes, they are. So due process now applied to the states. Equal protection. As long as the Bill of Rights didn't apply to the states, 2 systems of justice existed and undermined the authority of the Constitution. Separate but equal, Plessy versus Ferguson. Separate, inherently unequal, Brown versus Board of Education. And this thinking was the basis for the Bush v. So it was used wrongly, and whoops, one last slide. Got it. Used wrongly in Bush v. Gore in 2000, which was a 5-4 and wrong decision to stop the vote count. The federal overruling the state's right to count the votes. And I do hold Al Gore just a little bit. The Supreme Court was the ultimate perpetrator of wrongness there. But I have to hold Al Gore responsible too, because his strategy was, let's recount only the Democratic, strongly Democratic counties. You don't win. That was where the equal protection got violated. If he'd have said, I want to recount the whole state, what they would have determined, there were at least 2,000 more. All the missing voters were from Republican districts, not the Democratic districts. So if he'd have recounted the whole state, he wouldn't have violated that principle. The Supreme Court could not have stopped the vote count. Al Gore wins Florida, Al Gore wins the 2000 election. And I argue, and this is just me, that 2001 wouldn't have happened.
Right.
It wouldn't have happened for 2 reasons. One, Al Gore was a detail guy. If he gets the red light is blinking in the CIA, he'd have been on it immediately, and he would have known, and he already knew Osama bin Laden was a problem. They had told, the outgoing Clinton administration had told the Bush administration, you got to watch out for this guy, he's trouble. And we weren't able to get him. You need to be aware that he is a major bad guy. So, the Foundation for Incorporation. So we have 5 cases. Free speech was incorporated in Gitlow versus New York. Free press in Neer versus Minnesota, 1931. Right to counsel begins with Powell versus Alabama, 1932. Mapp versus Ohio incorporates the exclusionary rule that states cannot gather evidence illegally and use it in a trial. And Gideon versus Wainwright, that everyone has the right to trial in every situation. And according to Justice William Brennan, and he is one of my heroes, the 14th Amendment gave Americans a brand new constitution after the Civil War. And we should not walk away from it now. It matters. If you were born on American soil, you are an American citizen. End of discussion. That was originally meant to protect African Americans who Roger B. Taney said weren't citizens of the United States and could never be citizens of the United States.
The library is now closed and will reopen tomorrow at 10 a.m.
The library is now closed and we reopen tomorrow at 10. Now, do we have any questions?
Dr. Pete.
And if we do, I'm going to bring the microphone over to you so that the people online can hear it.
Dr. Pete, there is one question online.
Hi, okay?
Just,
Can you hear me?
I don't know.
So you talked about the wrong decisions the Supreme Court made.
Yes.
So where is the public's right to rein in the Supreme Court?
The right to rein in by the Supreme Court is to elect administrations of the other political party understanding that one of the major benefits of being the President of the United States is being able to nominate justices to the Supreme Court. Now, some of the and that's not always been the best person for the job, and that's occurred in both Democratic and Republican administrations.
So Tom, the Section 3 of the 14th Amendment does cover people involved in insurrection. It was brought to the attention of the Supreme Court, and I think it was Justice Alito, who refused to discuss whether or not President Trump was involved in insurrection, and chose instead, I believe, to broaden it and eventually got into this immunity thing. Would you clarify that?
I can't clarify the Supreme Court giving him immunity. I think that is unconstitutional. It's very clear that the Constitution intended equal justice. Everyone, including the President of the United States, was covered by the restriction that if you break the law, you can be taken to court for it. As far as, give me your Alito part again.
No, I believe it was Justice Alito who insisted that they not
Okay, I remember now.
focus on the insurrection complaint from a lower state, instead wanted to broaden it out and
Yeah.
come to immunity.
That was the nonsense. The reality was that the reason that phrase was put in the 14th Amendment was to prevent traitors to the United States, aka Confederates, from being able to hold office again. Unless Congress decides, there's an exception, unless Congress decides otherwise, they could grant them the immunity, they could grant them the ability but Congress had to do it. So, and it was designed to keep those who were insurrectionists, and I believe that Donald Trump was an insurrectionist. I think my own eyes tell me that. I watched that day, and I was saying the whole day, where is the cavalry? Where is the National Guard? And Trump never did call. He says he never called out the National Guard. I think that authority went to the Vice President of the United States. I think Pence authorized it. So he never, but yet now in the District of Columbia on the fictitious, in my mind, ridiculous idea that this is it's not a great, I mean, I've been to Washington, D.C. many times, more than 10 times easily. And are there some places I wouldn't want to walk in Washington, D.C.? Probably, yeah. Have I ever felt in danger there? I did not deliberately go, but I've walked all over that town and never felt, never had any crimes, ridden on the metro here, there, and everywhere. And so I think, in fact, the crime rate had gone down in Washington, D.C., and in fact, Trump had withdrawn funding that could be used to put more trained police officers on the streets, which is the critical. Trained local police officers on the street has been a long proven way to reduce crime in crime-ridden areas.
Dr. Pete, we have a question online.
Other questions? Anything is fair game.
Online, Dr.
Yep.
Pete, we have a question online.
Hi, can you hear me, Dr. Pete?
Final comment again. I wish I had you were as a high school.
Can you hear me?
teaching high school.
That's not,
Lisa, I think they're muted. I'm going to message George.
yeah, because I'm not muted here.
Hang on. Yeah, mute now.
The value of George Washington in this whole process, and that's amazing. And also that the Constitution, one of the things that made it so durable was it was so short, it was so brief.
Mm-hmm.
And it's in other countries. I think the Constitution of Brazil, you could use it as a doorstop. And people in Thailand had voted for Constitution like 6 or 7 times of their history. And people in Chile just didn't vote for a new Constitution. But ours has withstood all these challenges, and it still does today. Thank you.
In fact, when the Soviet Union used to exist, is there a hand up? Okay. When the Soviet Union used to exist, if you read their constitution, you would be amazed at all the rights that you had as a citizen that the government just completely ignored. Here you go, Wayne.
Tom, my question would be, what does the Constitution say in terms of the President's ability to declare emergencies and use that to suspend the Constitution?
It doesn't say anything about that. And I think that's a bit of the problem. What the founders had believed was that the most dangerous branch of government was Congress. That's why Article 1 is so much longer than Article 2 and Article 3. In fact, it's longer than Article 2 and 3 put together, easily. And they felt that the members of Congress, being closest to the people, would be better spokesmen for the people themselves, and they would be jealous of their authority and not allow a president to exceed the boundaries of what his constitutional powers were. So it's on MAGA Mike Johnson, and as the Speaker of the House, that he isn't asserting his authority and blunting what the president's trying to do by saying, no, tariffs are actually in Article 1. That's our discretion whether to or not to apply tariffs.
Dr. Pete, can you hear?
So a common term we're hearing is that we're in a constitutional crisis. How would you define that?
I would say we are in a constitutional crisis, and it is one that's going to be very, very difficult to back out of. Are we going to end up with an authoritarian government? There are some people that would like that. I'm not one of them.
You talked
Dr.
about
Pete?
the Bill of Rights, and you said that the first two of the ones that were proposed were not accepted, but later on two was. What was number one?
Number one had to do with how many citizens were represented by each district. And that turned out to quickly be a moot point because the United States was growing so rapidly. So it put a restriction of something like 30,000 people in a congressional district, which would be unworkable today. So that's why it never caught fire. The second, which was originally the original Second Amendment, was whether or not Congress could vote themselves pay raises, and then those pay raises go into effect in the same session that voted for them. That one said no, you had to wait for the next session, so that congressmen didn't literally benefit from giving themselves raises immediately. They might benefit if they get reelected in the next session of Congress, but not in the one that voted the raises.
Tom, the Fifth Amendment also talks about due process and right to life, liberty, and property. So under due process, to avoid arbitrary and capricious taking people into custody, how is due process supposed to work?
Well, the idea right now is that due process means you have the right to go before a judge. You have the right to have a trial, if necessary, to determine whether or not you have done anything that would entitle the government to deport you. And in the case now, it's not just hardened criminals who have a long established record of violent crimes. It's people that have lived peacefully, abiding by our laws, in some cases 30 and 40 years, and who have no criminal record whatsoever before they came here or during their stay here. And I think that behavior by the United States is criminal in and of itself.
And paid a lot of taxes.
Yes, they have paid into Social Security that they're never going to benefit from. Yes, George?
Got a question for you.
Okay.
Turn up the volume.
Go ahead, Lisa.
Okay, hey, thanks, Dr. Pete. At the very beginning of your presentation, you talked about federal rights becoming states' rights or becoming incorporated. And later on, you also quoted somebody as saying you cannot destroy the federal government through money. But I have to ask what your take is on the pretty widely now circulated idea of soft secession, where the blue states would take money actions, economic actions, to preserve their own rights.
Okay, I get the idea of soft secession. It's in many ways a reversal of the situation that existed in the Civil War, where the Confederate States wanted to secede because of the supposed abuses of the federal government. Basically, the abuse was that Abraham Lincoln and the Republicans said, we're not going to allow slavery into the United States territories, ever. End of discussion. Now, Abraham Lincoln said nothing about dealing. He actually did say, we're not going to touch slavery in the states where it exists because it is constitutional. So this, in a way of turning the idea of soft secession on its head, I think is a little concerning. On the other hand, what they are simply doing is threatening to withhold money that's going to be abused and used in ways that those states don't want. Now, that's a very fine line between that and what the Confederate States did. I'm not sure we want to go down that path unless it's very well thought out, and a union of blue states would in some ways be no different. To protect the Union might not be a whole lot different from the Confederate States seceding to protect their own vision of what the Union should be. That's worrisome.
Just going back to the earlier discussion. You can't hear me?
Okay, now?
Okay. Both Trump and Stephen Miller have said that a reason to not provide due process to the people who are being deported is because it would take 200 years to do that. Does the Constitution say anything about suspending due process because it's inconvenient?
Short answer, no. And it doesn't say that another argument that Stephen Miller, who I consider to be a modern Heinrich Himmler, just put a Nazi uniform on him and he looks perfect in it. That it doesn't say that they get this due process right because they're citizens. The Constitution says people. So it's quite clear that no matter who you are in this country, even if you're a foreigner, you're entitled to due process. Any other questions? Well,
Just a quick quote from Abraham Lincoln. Don't interfere with anything in the Constitution. That must be maintained, for it is the only safeguard of our liberties. And not just to the Democrats. Also, do I make this appeal, but to all who love these great and true principles.
I think that's good. Let me add one little thing about Abraham Lincoln and amendments to the Constitution, because he was responsible only for one, which was the 13th Amendment. But what you need to understand about how Americans generally, and Abraham Lincoln and specifically, viewed the Constitution almost as if you add an amendment to it, you are reducing the authority of the Founding Fathers. You are questioning their wisdom. And so that's why for such a long period of time, from about 1800 to 1866, 1865, January of 1865, you didn't have any, well, you had proposed amendments, but that they were so few because they didn't think it was, Americans thought it wasn't right to tinker with the Constitution. It was a near perfect product of the Founding Fathers. Yes, Darlene?
I don't know about anybody else, but I'm so frustrated now as an individual of what can I do that's going to make a difference in the direction that our country is going. Do you have any suggestions for us?
This is such a tough question.
I know.
What can we effectively do? You can communicate with your Emily Randall, in our case, who's a good lady. Communicate with both your senators, Patty Murray and I can't think of her name already. Maria Cantwell. Yes, it's the Cantwell thing I have trouble with. Maria I get, but the Cantwell thing doesn't stick. And but the problem is they're already blue people. So it's like you're preaching to the choir, but you, I think, still need to let them know. And I need to figure out a way. What do we do with our local officials? That's something where we might have a little more. So attend city council meetings, as boring as they are. School board meetings. There are a lot of small organizations where the right people in the right place will make a huge difference. And school boards are particularly vulnerable. Yes?
The Port Angeles City Council discussed the Border Patrol's actions with the firefighters at its last meeting. And this next meeting, there will be more discussion about it.
So the word is, we need to be there in force at the next city council. Would you happen to know when the next city council meeting is?
Yeah, it's every 2 weeks. It was just last week, so it'll be next week. Tuesday? Yeah, it's on Tuesday.
Next Tuesday?
The 16th.
The 16th. Tuesday the 16th, and what time do they normally meet?
Well, it's 6 for the general,
Okay, for the general period where the public can come in?
They start at 5 usually with a workshop.
Okay. I think it'd be good. I think we need to be there.
Don't forget the county commissioners.
And Washington is different in the sense of Ohio. I think we may have county commissioners, but they don't have as much authority as the county commissioners have in the state of Washington. And what's delegated to them is different. So, and we have, what, 3?
Yes.
And I only know one of them. And I can't remember her name. Yeah. And she is so bright and so excellent. I can't think. Phyllis Bernard. Right, Phyllis.
She's a
Oh, she is. Oh, okay.
That's different.
That's right. So this Washington thing confuses me. I'll freely admit it.
Johnson and French.
And don't forget, probably one of the most important things as well is we can't be complacent. We have to vote.
We can't be numb. We have to protect our right to vote by mail, which is such a no-brainer. Yeah, you would think, but it's.
You would think that he votes it himself
Yeah.
to the mail.
Yeah, I know it does, but what applies to him doesn't apply to anybody else.
You got that right.
Other questions? Well, thank you so much. It's been a delight to work with you guys. And we might have a session in the not too distant future on the 5 most important Federalist Papers, which are the best explanation of how the Founding Fathers thought our government should work.
And how would we find out
I
about
don't know everybody here. I know a lot of you, but if there are a few people who don't know who I am, will you send this with your email and we'll let you know when the next things are coming up?
And that's it.
Right, and the other thing you can always do is go to the Cloudoun County Democrats website. You don't have to be a member, and check the calendar. Vicki has been responsible for that, and so you get a pretty good idea if somebody's bothered to tell her what's going on.
Well, and also all these government organizations, you just go online to their websites and you can get
Right.
You can get their agenda.
Exactly.
Yeah.
Well, thanks again, everyone.